Welcome, everybody. Let's go ahead and get the program started. I'm going to spend just a minute or two talking about one of our very distinguished guests, Tom Metzloff, a summa cum laude graduate of Yale College, graduate of Harvard Law School, and who has clerked on the U.S. Court of Appeals for the Fifth Circuit, and then for the U.S. Supreme Court for Justice Byron White. He has been on the Duke Law faculty for about 25 years or so, and it's our great pleasure to have him here to help us see this really interesting program. Tom?
Thank you. It's a pleasure to be here. I want to thank all the folks at Washington and Lee who invited me to do it. David, Robert LeBlanc from teaches in the undergrad. She actually invited me up here about a year ago, right after I started filming, and I showed something that was not nearly complete because I hadn't finished all the interviews, so I'm delighted to come back here with a much more finished product. I don't know quite how I got into the new career after 20 years at Duke of making documentaries, but I'm very pleased, and it has a lot to do with the person who really recommended that I do the VMI case. Kate Bartlett was our dean. She's has a textbook on gender studies, very involved in some of the feminist legal issues out there. And she said, "You should do this." And my initial reaction was, well, the dean asked you to do something, it's probably a good idea to do it. So, okay. But when I first started with the case, I said, this is going to be easy. This was something that had to change, and it was, this 15 years ago. But then I started to read it and think about it, and I said, Kate, this isn't that easy, is it? And she said, no, really, there's a lot to think about in this case. This is an enduring case. This is a case about, an institution that didn't want to change, not because it just didn't want to change. It thought that it had reasons why what it was doing was appropriate. And yet we put it in the context of a movement to understand and appreciate equal rights for women, a context which includes the almost passage of the Equal Rights Amendment that does not pass. Every case in the Supreme Court is a case of a particular moment in time. And this is a case that is very important in the evolution of our understanding of the Equal Protection Clause. And it's a case that deserves our continued study. It turned out to be an absolute pleasure to work on the case. Some of the people I interviewed are here today. General Knapp is here, and Marie Whitmore, and I really appreciate all the help that they gave me. Everyone involved with this case on the VMI side as well as the Department of Justice were incredibly helpful. And you can't do a documentary without that kind of help. I mean, you need pictures, you need footage, you need to make it visually come alive. And I know that at the end of the day, having spent time across the way, law is a real thing. It affects us in profound ways, and it comes from places like Suzette Kilo's house in New London, a field in Virginia where a Ku Klux Klan member comes to do a rally, a vineyard in Middleburg, Virginia, where someone wants to sell wine in New York. These are real problems that affect real people, and I think why I have enjoyed doing these documentaries is because at the end of the day, we need to see these and encounter them at the level that the people who cared about them encountered them, on the street, on the ground. The Constitution, the Supreme Court requires that we have actual cases and controversies. That's a constitutional requirement. The facts matter, and as law students, you're becoming to appreciate that. And that's where I started. I think that's why I kind of like what I'm doing. I'm a fact-first guy. I want to know really what happened. When I was a litigator, that's my favorite part of the case was the beginning, when you could really try to learn and to say what's going on and what's happening. So I think this is an important case. I think it's a case that as you study it in constitutional law, like the 50,000 other law students who are studying this case is in every common law case book that I've seen. All the undergrads who study it in gender courses and civil rights courses, even all the high school courses. I premiered this case, and I think the VMI people will appreciate it, at a high school in Camp Lejeune, which is where the Marines train. I will tell you the reaction to that group, who were the AP seniors in history there, but I thought it was kind of an appropriate place to do it. So we will push the button. I hope I will push the right button, and I hope the sound works. So everyone say, hold your breath collectively here. I hope the video guidance is real live. All right, which button? Let's try that. Let's hope the sound is good. We did get, that was the VMI marching band, which Laura Brodie, who helped me with, her husband is the director. What's the proper term? Director. So I asked her if we could use it, and it said yes, and it adds a lot. And we do appreciate it. We'll get back to the main menu. So let me talk a few minutes about it, and then this is when some night you're sitting there watching a basketball game or something, the phone will ring, it'll be my mother, and she'll say, "What happened?" And I'll say, what? Because she had watched, I'll send them to her, and they always end like this without knowing what happens. Now, part of that is obviously very intentional. I mean, I could now tell you what happened in the Supreme Court, but these have been produced for students. And what I want you to do is talk about it and think about it. I'm not looking to put myself out of the job. These are meant to be active learning tools. And what I hope you do is then go, think about what you've seen. I try very hard to be balanced. The probably highest compliment I get from students is, "Man, I changed my mind 5 times during the watching it." Good. That's what I want you to do. And so I worked very hard, and we almost literally get a stopwatch out and make sure that we have as much time from the Department of Justice side as we do from the VMI side. That is my goal. I don't aspire to be a Michael Moore documentary maker, but something a little more challenging to you. So I hope that your teacher, your professor, will have the opportunity, after you've now thought about it, I hope are better and more sophisticated students of the opinion. As you read the opinion, you'll kind of see, how did the Supreme Court deal with this factual record? The other question she'll ask me is, well, what do you think? And I'm not agnostic. I have views, but I try to generally keep them to myself. I will let the panel speak of that. But I do have sort of 3 questions for you to continue this idea that it's really about how you as law students and observers think about this case. And one of them is the question of how do we deal with expert testimony? I was talking earlier with a faculty member here who teaches a course about the Daubert case on expert decisions, and also go back to Brown versus Board of Education. Supreme Court in a 5-page opinion changes the whole structure of many parts of the country's system. We all look back on that and say, good thing that they did. A lot of social science evidence is presented in that opinion, in footnotes and other things. We know in other cases, when they deal with the death penalty, they'll be citing psychologists and others. A lot of the evidence that was presented here, and you heard 2 of the main experts, was about educational theory. And I think Judge Niemeyer on the 4th Circuit really looked at that evidence and thought about what it meant. What do we think about how people learn? Do they learn differently? Are there significant differences in the learning styles between men and women? How do courts know what they know? I think that's one of the most interesting questions whenever you think about the Supreme Court. How do we know how corporations, if they have the right to participate in the political process? Do we go to political scientists? Do we go to social scientists? How do we learn from them? That's very much at the heart of this. There was this adversarial system. Joe Spivey just wasn't kind of kidding me. He said we were so dumb we didn't know what we were doing. We knew what we were doing, but we didn't know it had a name. There's a historical English system of education that is this adversative system. And yet you have Cliff Conrad for the Department of Justice saying this case isn't any different than the race cases involving unequal facilities. There's nothing, there's no opportunity for women to get this kind of experience. So I'm fascinated by how do you deal with the expert testimony that exists. Second question, and it's one that when I remember interviewing Paul Niemeyer, who I've known for many, many years, most judges don't think, they sort of say, our opinion speaks for itself. But I've been very lucky to convince some of them to talk to me. I was delighted to have the chance to talk to Judge Niemeyer, who has been an excellent judge on the 4th Circuit for many, many years. And I really said, what were you thinking? What challenge did you really give to those folks in Virginia with this parallel, comparable, equivalent, similar? I mean, what was the adjective? What could they do? Because it seemed to me to be almost an impossible task. Like from day one to start a new facility, a new program out of whole cloth that didn't exist and in some way put that on a scale and compare it to an institution that had been there for 150 years, who had illustrious graduates, who had a track record that is the envy of many, many institutions. What a difficult challenge. But you see his vision. It was, you had to give it time, and maybe Hillary Clinton someday will be there. Maybe there'll be some opportunity for it really to grow and become something special on its own. But it has to be time. If you look at it at any sort of real time that litigation is dealing with it, it's going to look very different. And so parallel, comparable, those are words that as lawyers we have to put some meat on. And they were hard. And I sort of said, I don't see, how could this ever have worked? And yet I understand the effort and the opportunity that the folks here took when they tried to go down that path, that the Fourth Circuit opened that door to them. And we'll hear a little bit. This is a case that really is, we'll see, thanks for what happened. This is really a case that, what is it now? What's going on a mile down the road here? And we'll get a chance to talk about that a little bit as well. So I have a third question. Let me look at my notes quickly here, because it's the third and a fourth question. I think that the main question, though, sort of factually, is a third point, and then kind of a more sort of systemic issue about how constitutional law works. I'm struck by, I still am grappling with minor accommodations. You hear a couple of changes. Throw some new, take 2 rooms, put up some new walls, put a couple of shades on some things. You got bathrooms for women. You got women's rooms. Easy. Piece of cake, he says, to change it physically. Okay, everybody acknowledges that. What about the culture? And you have this sort of profound vision of that this is a radical change to a culture of an institution versus the Department of Justice saying, we've heard that before, it's not. The same way that you accommodate, it's accommodation, it's not radical change. And I don't know how to access that. I didn't go to VMI. I can see it, and I think it helps a great deal that I have had a chance to see it, and you've seen some of it too. I've been in the barracks. I've walked in that, right by the least. If you've been on the outside, beautiful building on the outside. Not quite so beautiful on the inside. Over the wall, and you can be whoever you can be. Is that what? Something like that. Well, you can be whoever you resolve to be. I thought you should say, beware all ye who enter here. Dante's Inferno, perhaps, might be more, especially if you're a rat. But it's an amazing place. It's the front view and the back of the house. And there is a cultural change. And that's what's so fascinating about the institution. You see the experts, mainly through the experts, but also through the people who testified. And you saw the people you saw here are the people who testified. This really was the heart of the record that the Supreme Court had, and in the eyes of probably the VMI folks, that the Supreme Court largely ignored as they went through the facts of the case. But which is it? Is this institution in that barracks only, or is it the whole thing? The faculty at VMI, while not specifically asked to vote on this, the majority had thought coeducation would be fine. That they thought they could bring in sort of more students and the like. So the last question is a more metaphysical one that we deal with all the time with constitutional law. And it's appropriate to think about today as we have an election tomorrow. I mean, how much of what we do in our society should be a function of the democratic process? And how long, and when is it that the institution of the Supreme Court should, in a sense, step in and change the democratic process? What would happen? Where would we be 15 years now, 15 years after the decision, if this had not been litigated? It would have been an issue. It was an issue in the political and Commonwealth of Virginia. Would VMI have changed on its own? Would they have made some accommodations on their own? It's the same issue we think about today with same-sex marriage. Is it something that we should continue to grapple with through our democratic institutions, through discussions amongst ourselves by those who want change and those who don't want change? Or is it something when we're better off, in a sense, letting the Constitution as interpreted by the federal judges, the federal courts, the Supreme Court come in a sense, take that issue from us? I don't have an answer to that. We know sometimes that we don't think the democratic process will work. It may have been way too long before we would have changed separate but equal in our segregated South. Hopefully it would have changed. Who knows? So we think about all these issues. In some ways, there's a lot of argument for saying the democratic process, as difficult as it can be, maybe achieves some of these goals in a way that's different, in a way that might be more profound. We're still fighting battles about abortion. It's not like we put that issue behind us, is it, as we have these elections that continue to turn on that. So that's that's in this case as it is in so many cases. But what I'd like to do now is show just a short, what we call aftermath. I don't always do this, but this case begged for it. I mean, you have to know what happened in this case. Where are we now? So if I get this, let's see if I can get this to go back to the beginning. And go over to the aftermath. Let me say a word about the party narrative. For those of you who lived through this time, and I think maybe even some of the law students will remember this, the public face of this controversy was not Lexington, Virginia, and VMI. That was always the main case. That was the case that was being primarily litigated. The public face was the Citadel, and a young woman named Shannon Faulkner, who is now teaching English in high school in Greenville, where she grew up. And the party narrative is available on our website, which is on the Duke Law webpage. If you find the Voices program, it's a program in the center. We won't show it today, but I was fascinated to find Ms. Faulkner and talk with her about her ordeal. It's an interesting story. She was not a crusader who from age 5 said, I'm going to take a case to the Supreme Court. She was a high school senior whose mother was bugging her to apply to colleges. And it was January, and she hadn't done it. And as part of her course, she was going to be a teacher. They had to go find an article. She found a Sports Illustrated article about hazing at the Citadel. She read it and said, I guess I can't even go there if I wanted to. She picked up an application. It didn't say male or female on it. So she said, I guess I'll apply. And she applied to 4 schools, and she said, I'll go to whichever one I get in first. And she got into the Citadel first. Her name is Shannon Ritchie Faulkner. If her name was Elizabeth Mary Faulkner, she never would have had that issue because they would have known. And once they told her no, she said something like, well, I'm a teenager. If you tell me I can't do something, that's what I want to do. So she sort of stumbled, as some of our plaintiffs, our most famous plaintiffs do. Some of them are very dedicated. This is their life's mission. But she stumbled into it, and she stuck with it. She had a tough time with it. And most of us know the story that once she's finally ordered, she actually attended day classes there for 2 years. And it was hard because she, most of the cadets didn't talk much with her as a day student. When she finally, after the VMI case, is told to go in, she didn't last very long. And some people look at her and think but it's an interesting story, and if you're interested, do watch. But let's watch a little bit of the aftermath and what's happened to VMI.
Okay, let's go ahead and get started again. Without further ado, I'm going to call on my colleague Ann Massey, who will introduce the panel and get this part of our program going. Ann.
Okay. Good afternoon. Great to have you all. I see community members here and college students and just a real mixture, and that's just wonderful. Thanks to Tom for that interesting, well done, provocative movie. It really does make you think about both sides, I think. So we have some panelists here who are experts in various aspects of this whole scenario that we've been looking at and talking about. First we have Marie Whitmore, to my left. She's a partner at the law firm of McGuireWoods in Richmond. That firm stepped in to represent VMI on behalf of the VMI Foundation because the Department of Justice was suing VMI and the state of Virginia. But the governor of the state of Virginia at the time, Doug Wilder, said he didn't think the VMI male-only admissions policy was right. He thought they ought to change it. So the Attorney General, Mary Sue Terry, said she felt that she was conflicted by having to represent a position different from that of the governor. She asked to be released from the case. McGuireWoods stepped up to the plate voluntarily, said they would represent the foundation and argue the VMI case free of any cost to the taxpayers. So Marie Whitmore worked on this case from the first trial to then the Fourth Circuit Court of Appeals, back to another trial, and then another appearance before the Fourth Circuit Court of Appeals, as you saw, Judge and you and I are talking about, and then worked on the brief that went to the Supreme Court and sat at the counsel table with Theodore Olson when he argued the case before the Supreme Court. So she has been was part of this case from the very beginning. She knows more about it, I suspect, than anyone else in the room. We also have with us Colonel Michael Strickler, who is also an intimate of the case from beginning to end. He is a graduate of VMI in 1971, when it was certainly still all male. He had the very busy and perhaps unenviable position of being serving as the Institute's Director of Public Relations during this whole time that we are talking about. He was a very busy guy. He was constantly on TV, in the radio. He got much more than the proverbial 15 minutes of fame. Well-known guy around here, and still is. He's still at the Institute. He's now the executive assistant to the superintendent, and he serves as secretary to the Board of Visitors. We have Laura Brodie, visiting professor of English at Washington and Lee. She's written several books, both fiction and nonfiction. Of course, she's here today, as you have already seen, famous for her widely acclaimed book published by Pantheon in 2000 called Breaking Out, VMI and the Coming of Women. Then we have our own Russ Miller, a faculty member here at the law school, where he teaches constitutional law and also comparative law courses, and enlists students to help him publish an online journal, the German Law Journal, which is highly respected internationally. He's a particular follower of Justice Ruth Bader Ginsburg's jurisprudence, and he's written 2 articles about that subject and is working on his 3rd. So he is here in his capacity as an expert of Justice Ruth Bader Ginsburg. I am here as a constitutional law professor, and I was here through the whole thing. Started out with VMI as a hypothetical in my classes, and we would say, now what would happen, if a woman were to apply at VMI, and then we would say, no, it's not going to happen. Well, of course, things changed, and then every year the posture of the case changed, so I got more final exam questions out of that case than you could believe. But now we're going to hear the story behind the story. Thank you.
Thank you very much, Ann, and it's delightful to be with you all today. And Tom, I think that film is exceptionally well done, and I congratulate you on that. I have to differ with you, Ann. There's one person in this room who lived the case as much as I did and knows probably even more than I, Skip Roberts, who was actually my client, the executive director of the VMI Foundation through this period of time. And then, of course, General Knapp, with whom I worked very closely also. I think the documentary gave you a very fine perspective, especially on the expert testimony that we introduced on behalf of VMI. But let me give you just maybe a couple of different or additional observations. One is that we knew from the very beginning that this case was going to go to the Supreme Court. And that's very unusual. Those of you who are students will find in the practice of law to know from day one when you open a file that you're going to the United States Supreme Court. And we knew that even before the case was filed. We knew it because of the decision in Hogan versus Mississippi University for Women. That was the case brought by a male who wanted to attend nursing school at the all-female Mississippi University for Women. And it was very clear from the opinion in that case that the Supreme Court was saying that the reason that that male was constitutionally entitled to admission was because there was no record in the case, no factual or expert testimony to satisfy the test of intermediate scrutiny. That is, was there an important governmental purpose, and was the policy substantially related to that purpose? So we started from the very beginning, setting aside all the emotions, which I'm sure you can understand existed, both the strong emotions of the VMI community and the strong emotions represented by Marcia Greenberg. I was struck by the fact that she characterized it as an anachronistic position that was being taken. So what we had to do as lawyers was to really drill down and determine whether we could show factually and through expert testimony that we satisfied the intermediate scrutiny test. And the starting point was the mission study that you heard reference to in the film. And that mission study was set up in light of the Hogan decision in order to make a determination of whether there was a sound educational basis for restricting VMI to men. And a couple of facts you should know about that study was that, number one, it consisted of a majority who were not VMI graduates. Number two, it was based upon, in large part, a study not only of VMI, but of the service academies and what had happened at the service academies when women were admitted. And granted, the service academies continued to do a wonderful job, but there were changes that took place at the service academies. And that was part of the basis for the conclusion that the admission of women would change VMI. And interestingly, that study also said that from the standpoint of the Commonwealth, if we admit women to VMI, we will have a coeducational military school, which is what exists already at Virginia Tech with the Tech Corps of Cadets. So that mission study was part of the foundation of the case. And we set out, and I think you can hear from the film here, to establish, first of all, that single-sex education has significant pedagogical value. And none of the experts for the Justice Department disputed that. In fact, one expert who came in the second stage of the case, Alexander Aston, who probably had done more research on single-sex education than anyone else in the country, we wanted him to testify because his research showed that single-sex education was valuable both for men and for women. And he wouldn't testify because he didn't believe that single sex should be offered at a public institution. Cliff Conrad, who you saw, Cliff Conrad says, yes, single-sex education is very important, very valuable, but I'm not in favor of it at a public institution. So here we had educational experts whose opinion as educators supported our position, but whose personal political feelings influenced how they approached the case. That having been said, we made the record undisputed that single-sex education served an important purpose for some men and for some women. And we also made a record that there was a unique single-sex education at VMI. And the experts agreed that there were developmental differences between men and women. So we prevailed, as you know, in the lower court up through the Fourth Circuit. We established the separate program for women at Mary Baldwin College. And what happened when we reached the Supreme Court? Well, I know the constitutional authorities will differ with me in this regard, but I think that Justice Scalia's dissent, where he goes very carefully through the record, shows that we satisfied what the Supreme Court had said was the test in the Hogan case. The majority opinion elevated the concept of an exceedingly persuasive purpose which in Hogan had been a description of the burden, not the test. But that seemed to become the test, as pointed out by Justice Rehnquist in his concurring opinion. And because the record was undisputed that some woman could do everything that a VMI male was asked to do, that in essence it was an overgeneralization and an unconstitutional overgeneralization to exclude women from VMI. The catch-22 that was referred to by Justice Niemeyer actually came from Professor Richardson. And he said that this is the irony of the VMI case, that a woman who wants the VMI experience, by definition, cannot have it because it's no longer a single-sex institution. And there will be changes, at least changes over time, that will affect the culture and the adversative method. We never said that VMI could not be a successful coeducational institution. We said it will be, over time, a different institution that will serve an important purpose, but it will no longer be part of a very rich single-sex experience that we argued was an important governmental purpose for diversity in higher education. I look back on the case now, and it is absolutely true that if we were trying this case today rather than 15 years ago, we would have an abundance more of literature about the value of single-sex education for men in particular. I think most of you who follow education will know that, ironically, it is young males who are now viewed as underserved by education in our country. It used to be women, it's now young men. And I think it's unfortunate that the result of this litigation, notwithstanding the evidence that we had at the time, was to really undercut the benefits of single-sex education for both men and women that's publicly supported. We don't have a perfect educational system, and I dare say that, in my opinion, courts should not be making educational policy. And that's really what this VMI case was about. It was about education, good education, demonstrably successful education. It was not about discriminating against women. But it was, as a lawyer, a great experience. I think that VMI has acted, as you would expect, responsibly and conscientiously. Thanks.
Well, first, had I known General Knapp was going to be here, I would have gotten a haircut today. I certainly don't want to go back in this late stage in my career and get some demerits from VMI. I am what a lot of WNL folks would call a VMI. And I've worked at VMI for 35 years, and also spent 4 years sequestered in the barracks over there as a cadet. Some might wonder what I might have done to upset the good Lord. But it has been and continues to be an incredible journey, as General P., our current superintendent, talks about VMI. It's a 4-year journey for me. It's been about a 39-year journey. However, I do have a few WNL family connections. My middle brother is a 1971 law school graduate of Washington & Lee. And both of our children, who seemed to think they were much more enlightened than their father, decided they'd come next door and go to Washington & Lee. So our son is a 2003 graduate, and daughter a 2006 graduate of Washington & Lee. Court case over admission of women and the eventual assimilation of women coming to VMI. It was basically paralyzing to VMI for, I would say, about a 5 or 6 year period. Now, the case itself goes over from the time it started to the time we had to, we were let off of the reporting requirement to the courts was well over a decade. But there was a 5, 6 year period where it was very paralyzing. It was invasive on every level. The Board of Visitors, the administration, certainly cadets, and of course, the alumni. However, we had to do what we did with the court case. VMI is a special place to its alumni, and giving up on the single-sex status without contesting the issue would have been far more divisive to our alumni body. It just, could have simply crippled VMI and would definitely have crippled fundraising if we hadn't fought the good fight. Besides, we have been pretty successful as an all-male institution for 150 years. So it was definitely worth the fight. In my area, I was PR director from 1992 to 2001. So I took the job, thanks to General Knapp gave me that job, right at the wrong time. I will mention 2 short vignettes that I dealt with to give you a flavor for what was going on at that time. The first was in May of 1993. One of the decisions from the courts came down on Monday after VMI's graduation on Saturday, and I was the only game in town. General Knapp had gone out of town on business. There were no cadets around. There were no faculty and staff. It came down on a Monday, and the media descended on me and on VMI. By 5 o'clock that afternoon, there were 6 satellite trucks at VMI. I spent the 5:30 to 6:30 news going around to each satellite trucks and doing live broadcasts on their 5 and 6 o'clock news show. So it was that was one pretty amazing time. The other is the first day of women coming to VMI, and this has a little Washington Lee flavor. You've seen some of the background that VMI went through to prepare for women. We prepped a full year. We wanted to do it right, and we recruited 30 women to come in first class. And on that day of matriculation, incidentally, we had about 260 media from 65 media outlets, including 4 international televisions, with about 30 satellite trucks that were ringing the parade ground. I mean, it was amazing. We spent basically most of the summer preparing for it. Well, early that morning, I had my cell phone out on the parade ground, get a call, and they had found 30 dead white rats on the parade ground. And I went, oh, this is great. The media, of course, saw it. It immediately went out on over the wires, and by 10 o'clock that morning, CNN was broadcasting that VMI was already being hostile to the 30 women who were coming in. Somebody had put dead white rats on the parade ground, so we were already in trouble. But luckily, I had a good relationship with a number of the media, and by about noon, they had run the story down, and some of our couple of erstwhile W&L students who were here over the summer had raided the Washington Lee biology lab the night before and taken 30 dead rats and dumped them on the VMI parade ground. So thank goodness by about 1 o'clock the actual reports were coming back in, and at least that part of the day calmed down. It's just as incidentally at VMI now with the assimilation of women, we have 140 women in the Corps of Cadets right now. It's about 9%. Our goal is between 150 and 200. We hope to reach that. Our numbers to date, the admission of women's up about 8% from this time. Over last year, we had the largest number of women come in August. We had 59 women in the incoming class. It was really an incredible experience for me to deal with media on that level at a small school. Very few PR directors have that opportunity. It's one I'll certainly never forget, but one I don't want to do again either, I can assure you. Finally, I must say that I am indebted and will be forever in debt to one of our panelists, and that's Marie Whitmore. I learned early on that when these decisions came down, and there were many of them, I knew where to go to get somebody to explain it to a layman. She could even make it understandable to this dumb history major. And I will be forever indebted. She was the first one I called, and at least I could then talk to the media, TVs, radio, whatever, and at least be semi-intelligent on what I was talking about. Anne Marie, I really appreciate that very much. And that's
I'm bringing my water because I have the cough that's going around, so you'll have to forgive me. I wanted to tell you a little bit about how I came to be writing a book about VMI, and then share with you some of the issues that concerned me most when writing it, and that still have some existence today. When the Supreme Court case was ending in 1996, I was finishing a PhD in English literature at UVA, and I stressed my background in English because I know nothing of law. My interest is in stories, in narrative, in character. I write fiction as well as nonfiction. And so in the summer of 1996, the best story in Lexington, Virginia, especially for someone like me with a background in women's studies, was the possible introduction of women at VMI. So I went to Cy Bunting and said I would be interested in chronicling this process. I'd be interested in gathering stories of male and female cadets and administrators and faculty, and speaking to alumni. And my original vision was possibly an oral history, although it evolved from there into a more journalistic project. But I said, it'd be nice to chronicle this transition, and who knows what I'll make of it. I said at the time, VMI could use a history. I might make some articles or possibly a book out of it. I didn't know if anything would be published from it. And General Bunting was incredibly generous and incredibly open. He, as the film said, he invited me to serve on his executive committee for Coeducation, mostly taking notes, although sometimes welcoming my opinion. I was one of two women in the room. Kathleen Bulger-Burnett, some of you might know, who teaches at VMI and who gave the swimsuit story I was telling there. She was in the room sometimes. I was just teaching English for one semester at VMI. That's the only official standing I had at VMI. But General Bunting, as I say, he was very open. He felt VMI had nothing to hide. The dean at the time, Alan Farrell, who's a good friend, he was like, oh, you're crazy. You're letting Laura watch everything we do and write about this. He talked to me about that. And Alan was saying, as he knew, that I am a feminist, as I say in the opening of my book. I'm a feminist, but I'm not a witch, and I'm not a man-hater, and I'm not an inflexible opponent of all things patriarchal. So, but I had a lot of skepticism about some of the things that are done at VMI, but no one has more skepticism than the cadets themselves and faculty and administrators. That's part of the process at VMI. But General Bunting allowed me to do this in part because I am part of the VMI family. As Tom Metzloff was saying, my husband has been the band director at VMI for 23 years now. I personally know lots of cadets and faculty and alumni, and so I think the hope was that my knowledge of VMI and my concern for the individuals, a lot of wonderful people at VMI, that might be balanced with my perhaps more liberal inclinations or more feminist inclinations than some of the folks at VMI. Between those two, I might offer an objective story. And I was interested in humorous stories, serious stories, just people's voices, bringing them all together. And I should say the people who were most skeptical of all were the lawyers in the end. When I actually got a book contract from Pantheon, which was during the first year of Coeducation, I don't remember the name. I don't know if it was your particular colleague or someone in Richmond who was working closely with VMI, and he told Mike Bissell he could not believe that General Bunting was allowing someone to write about this process as it unfolded. You wanted the clients to be quiet and not publish information that the Justice Department could possibly use. And he was so upset, he told me he might try to get some sort of legal injunction to block the publication of my book. And I said, well, you should see what I'm writing, because in fact, VMI, especially during its first year, was doing an incredibly diligent effort to prepare for women. They had dozens of committees and subcommittees looking at everything from swimsuits to any need for new academic subjects, to bring in the psychology major, to bring in teacher education, things that women might historically have a little more interested than some of their male cadets had, to look at facilities and uniforms and every detail. And of course, we can laugh at the swimsuit story, and I want people to laugh at some of this, and VMI laughs at some of it. But we need to understand that VMI went through a year of incredible planning for women, really unprecedented, to try to make sure that they didn't make the embarrassing mistakes that the Citadel made, and to go about their planning for this process in a thorough manner. The lawyer who was concerned about my book, I showed him an initial copy, and he didn't want to block the book at that point, but he asked me to take out the little segments where it ever said that the lawyers advised VMI to do something. He wanted no reference to legal things. I think his name was in there once, and I don't even remember what it was now. I have not been involved in scholarship on VMI in 11 years now. But Sally Weiss said, oh, she was so disappointed. She would have liked to have seen what the lawyers were telling VMI. That was the story that interested her. So that was removed, and what we wound up with is a book. Half of it is on the year of planning, and which, as I say, was the earnestness of VMI in preparing for women. It was very striking. And then the first year of Coeducation, which, as he said in the film, was successful. There is an afterword in my paperback version that does mention that the second year of Coeducation was much more rocky for many reasons. That they had almost a 70% attrition rate of the women that came in, whereas between 30 and 40% is more normal at other times. And so a lot of the frustrations that they were able to hold down over the first year came out in some of the male cadets' behavior. And in the second year, they also didn't have a cohort of women who were as serious in some ways about being pioneers and sticking it out. And they had a problem with the regimental commander. And some of you have read in the past cases of getting sexual favors from female cadets, female rats, and all the things that you'd think, well, yeah, these are things that can go wrong. And the indications of the type of problems that rise when you have a co-ed school versus a single-sex school. Some of those were really coming up in the second year, but things have smoothed out after that. So what the issues that I just want to point out that interested me most, because my background is in women's studies, are what's involved in assimilating women into a male culture. Because VMI didn't want to talk about coeducation. They didn't use that word often. They kept saying the assimilation of women. And assimilation can be a sinister word. But what it meant here was, especially in the first few years, trying to change as little as possible and just tell the women, you can be here, but you have to you wanted the guys. The film was talking about haircuts, and although General Bunting originally threw out the statement, buzz cut, which got a strong reaction, as you saw in the film, the hair has gotten longer over the years, but you should be aware that on that, at that initial haircut, what they did for women was give them a little over 1 inch of hair. So that was the first group of women to come in, and part of the problem with that was they did look like young men. They looked like boys. When the group of female rats in the first fall went to Arlington Cemetery for the opening of the new memorial for women in military service, the MC of the event, the head speaker, introduced them as the young men from West Point. And it was disturbing enough to have someone at a distance look at them and say, oh, those are the young men from West Point. But they said then people at the end of the event came up to them face to face and were thanking the young men, for supporting the women and coming here and supporting this women's memorial. And the female cadets were telling me, they didn't correct people because they felt so embarrassed that people were shaking their hands and assuming that they were men. And most of the women that I interviewed had stories of being told, to get out of the women's room. One woman, Nikki, had a funny story about a senior citizen who was hitting her with her purse, attacking her with her purse. She's saying, young man, you have to get out of the bathroom. So what is this issue? I think VMI has gradually tried to let women show their femininity a little bit more, at least let their hair get longer. Mike Bissell was saying in the film, V-Will lets women be feminine. VMI tries to make the women into men. It's a tension that still exists at VMI. We said in the film when the first skirt was worn by a young woman, sophomore year, a male cadet boned her. And boning is another word that's problematic at VMI, but it's, he reported her, and the commandant staff had to decide, would you allow women to wear skirts in class? And they said yes, but the other female cadets were telling her no. The women were saying class unity depends on our uniformity, our being just like the guys. So we need to look like the guys, we need to act like the guys, and administrators were always concerned about what do you create when you have young women who want to act like the guys. They want to wrestle with the guys in the barracks. They want to use language like the guys use. The VFT is another example of the film was talking about the VMI fitness test. Can you have women do the same test as men? And this fitness tests are always controversial in all the services. And up until July of 1998, in the Army, for instance, the Army standards at that point were saying that women could do, women could do 18 push-ups as a minimum Army standard. Men had to do 54 push-ups. It's the minimum Army standard. Women, the minimum standard would be to do a 2-mile run in 18 minutes, 54 seconds. Men had to do it in 15 minutes, 54 seconds. And women were succeeding on their fitness test at a much higher rate than men because of that. And that gender norming, a lot of people felt was discriminatory. And those standards have been changed and made more stringent for men and women since that time. VMI argued we should have men and women take the same test, which at the time included for the minimum standard, and I think I did write these numbers down again, and Mike, you can correct me, but I think 60 sit-ups in 2 minutes, 5 pull-ups, and this is the tough thing. Women do not chin-ups, but pull-ups this way, and doing a 1.5-mile run in 12 minutes. That's what you need to do to make a D. And so VMI was the first place that said, yeah, let's have women and men take the same test. The film had one little error. It said that the test was required for graduation. No. The only way VMI got away with it for 10 years of not gender norming standards was they said, why not have women and men take the same test as long as the consequences of failure are not severe? The only consequence was it affected 25% of your grade in a PE course, which was a half-credit course each semester, a total of 4 credits. Now, last year VMI changed its fitness standards. I don't know what the current standards are for women and men, but they did ultimately decide to gender norm them. That was controversial. A lot of women didn't want that. They said, keep us at the same level. The PE department always wanted it. From day one, they said, this is what's done by our colleagues. They felt they were being required to lower women's grades because they couldn't perform at the men's standards, which they, as faculty members, objected to. So there are lots of cases where what happens when you try to treat women as men, and to what extent is VMI changing to allow women to be women. The last example I'll mention, which is always controversial in my mind, is how to handle pregnancy, which VMI handles by calling it parenthood. And in the 2007 Blue Book, I don't know, Mike could tell me if it has changed in the last couple of years, that the policy is young men and women who become parents will be expected to resign. So I assume from that wording they're not required to resign. And they will be separated from the Corps. I'm not sure what that means if you don't resign. Does that mean you live in the hospital, which is one thing that VMI considered when they did have a female cadet get pregnant. But prior to 2007, they had a pregnant female cadet, and she was allowed to stay through her second trimester. I don't know if she ultimately got her degree and came back later. But I think clearly there are things where women and men aren't the same, and you're not going to be able to treat the women as the men, especially with something like parenthood. You know, I do see that as a possible issue for VMI in the future if you have a young woman who is pregnant and who doesn't resign and wants to stay and stick it out, since parenthood cannot be monitored for young men as it is for women. VMI had actually several notable male cadets. Some I knew personally who openly had children while they were cadets at VMI. So there have been those sorts of issues to deal with. And the last thing I'll mention, in the film I say I don't really consider VMI to be a co-ed school. In part that's because they don't use the word coeducation all the time. They often still use the word assimilation, that they're trying to do something different from coeducation. And in part because I think they need to get the numbers up, the numbers of women up in order to have what is considered really coeducation. It still, to me, seems like a men's school. People say, well, it's changed fundamentally. I don't know that you have enough women to really have fundamental change there yet, but that's something the alumni can gauge better than I can. But I do hope VMI is successful in the future recruiting and retaining women, because it's awfully hard to get them to want to come, and even harder to get them to want to stay, especially when they can go to the national academies for free. So VMI has been making an incredible effort, and whether or not it is ultimately successful in the end, I think still remains to be seen.
Thank you very much. I'm thrilled to be doing this, largely because it was such an exciting collaboration amongst a number of my colleagues who never met. It was an amazing process to see. I wanted to check my email inbox this morning to get a tally on the number of emails that went back and forth between our colleagues, and it was really encouraging to see how we could pull this together as a group. So I was grateful for that. It's also a thrill to be able to teach the VMI case from a classroom that has windows that open up onto the VMI campus. It's a rare opportunity for a constitutional law professor to have the object of the case present at the time of teaching each year. Well, it's clear from the film, which is excellent, and I'll use it in the future to lay a foundation for the facts and the background of the case. And from the discussion that the case changed VMI in some measure, but I think it's less clear, maybe even less clear than you give us con law types credit for what effect it had on 14th Amendment jurisprudence. I think that's less clear. It's possible that it might have elevated gender to a suspect classification. It's possible to read it that way. Maybe requiring that gender distinctions in the law be tested by strict scrutiny. And if that's the case, you have to wonder if this is just a strategic misreading of the Hogan opinion. It might be that the VMI case is just a case-specific elaboration of Hogan's intermediate scrutiny, that it actually relied only on intermediate scrutiny, but found that the evidence presented failed to meet that standard. That's a possible reading. Another way it's possible to read the case, I think, is to say that it's just a version of rational basis with a bite. It's just read maybe on steroids. So it's a bite with sharper teeth, but it's just rational basis review. I tell my students, at least, that it's wise not to neglect any of those possibilities in their litigation. And I think it's worthwhile highlighting all of those possibilities because it reveals for us the limits of relying on tests and tiers in constitutional jurisprudence, that there's a lot of fact and judicial consideration that have to be considered, that evade mere tests. if we wanted to know which of those possibilities, or of any possibility, if we wanted to know what the Virginia case really means, I think we could do much worse than to ask Justice Ginsburg. And not only because she authored the opinion and was the strategist and chief architect of a decade's worth of litigation before the Supreme Court that has changed the gender equality jurisprudence in our country, but also because I think if there's one woman who could, without question, have met VMI's standards at any stage of its development, it would be Justice Ginsburg. If you see this diminutive character present, you see a kind of internal strength and integrity that would do any institution great pride. It's worth remembering that that she was raising a child and caring for her cancer-stricken husband while serving on the Columbia Law Review to finish her law school career. She is, as far as I know, the only person to have served both on the Harvard Law Review and the Columbia Law Review. And she frequently notes that even against that record, she, like former Justice O'Connor, were offered only legal secretary positions on graduation. All right, so I think it's worth pausing to ask whether or not we can make some conclusions about what the Virginia case might mean for 14th Amendment jurisprudence from the perspective of Justice Ginsburg. And that's a position, a posture informed largely as well by President Clinton at the nomination ceremony when she was presented to the press in the Rose Garden. He said that Justice Ginsburg, then Judge Ginsburg, is to the women's movement what former Supreme Court Justice Thurgood Marshall was to the movement for the rights of African Americans. So, what is Justice Ruth Bader Ginsburg's notion of gender equality? There's been a lot of writing on the question, and I would refer you to a number of far more competent commentators than me on that question. But I'd like to give you a distinct window into a possible answer to that question from the perspective of a project that I'm working on, which I'm roughly entitling Justice Ginsburg's Comparative Law, because it's a little-known fact that Justice Ginsburg began her career as a law professor, as a comparative lawyer. And I like to emphasize this because it gives all of us often deemed irrelevant and academic comparative lawyers hope that we might still all reach the Supreme Court someday. So that's less well known that she began her career as a comparative lawyer at Columbia University's Comparative Law Project, which required her on absolutely no foundation to become an expert on Swedish civil procedure. And in the vein of that start to her academic career, she published a number of books and a number of articles, both at Rutgers Law School and then later at Columbia when she returned there to teach, where her daughter is now also a member of the faculty, all focusing on Nordic civil procedure. Now, it's not just my curious interest in Justice Ginsburg and comparative law that makes that potentially relevant for us today. In a 2009 interview at a panel at Ohio State University, she made the connection herself. She said, when asked, why was it in the early 70s that she abandoned, as if you might have to ask this question, why would you abandon Swedish civil procedure for equal rights jurisprudence? And she said, frankly, my eyes had been opened in the early 70s while I was in Sweden. First by reading Simone de Beauvoir's awesome book, and she used the word awesome, The Second Sex, and then by listening to the debate going on in Sweden about how families should divide their work. Wherever I went in Sweden, people were debating that question in the mid-60s. I was listening to it, and that process slowly awakened me to issues of the same questions in the United States. That, she said, accounts for the turn in my concentration from comparative law to gender equality litigation and scholarship. She goes on to note that knowing a little bit about civil procedure doesn't hurt in your litigation on these questions as well. That highlights for me a couple of possibilities that we might read into her jurisprudence about equality jurisprudence. One you could extract very specifically from the work of Simone de Beauvoir and the book The Second Sex. In the in a chapter of the book named Women, Myth, and Reality, Beauvoir argues that men had made women the other in society by putting a false aura of mystery around them, an aura that men would use as an excuse not to have to get to understand women better. That is a kind of stereotyping that is perennially used by those in a higher order in the hierarchy in society to distance themselves from and to generalize about those who are lower in the hierarchy in the society. But Beauvoir was convinced that this had especially been deployed with respect to women across all societies. This treatment and mystification as the other in order to stereotype and to treat them differently. The other lesson that Justice Ginsburg surely learned and is documented then in a 1972 article in the American Journal of Comparative Law is not just this concern for stereotyping, but also an interest in a passion for the possibility of formal equality of the genders in society. And they're really different, substantively different ambitions with respect to reading the 14th Amendment. Ending stereotyping, or perhaps reading it maybe in a remedial sense to actually achieve formal equality. In this 1972 article, Justice Ginsburg explicitly argues, it's called The Status of Women, and it's mapping the status of women in the law around the world in a comparative assessment. And she says at the very beginning, I hope that this project will cast a comparative perspective on some of the problems that we encounter with respect to this question in the United States. And she identifies a number of very specific issues in which there might be the possibility of achieving formal equality. And then always offering, too frequently, I think, Scandinavian examples to support her position. But the fact that the Scandinavians and the Soviets, for example, had given up on laws that required women to accept a male's last name upon marriage. She notes Nordic and, again, Soviet law that had rendered child support provisions gender neutral. She identifies the fact that especially Sweden had eliminated legal distinctions for children born out of wedlock, creating a formal equality for the various constellations of partnerships that people might construct in society. And then lastly, she praised Sweden's elimination in 1971 of the elimination of tax disincentives for two-income families. All right, those are two possible values, ambitions, maybe even feminist claims that could be read into Justice Ginsburg's gender equality jurisprudence, this notion of anti-stereotyping, and then the possibility of formal equality. And I just wanted to say just a couple of words by way of an assessment, sort of a report card, on how well she might have done, given her great chance in the Virginia case as the author of that majority opinion. And it's my view that with respect to stereotyping, the Virginia case stands as a remarkable success. And it's very clear that Justice Ginsburg, throughout the opinion, is very conscious, is keenly aware of the possibility of this in the Virginia case. There is this repeated sentiment with respect to concern for stereotyping throughout her scholarship and in many of her opinions. And that's most evident in the fact that the strategy that she pursued with respect to gender equality as an advocate for the ACLU in the 70s often employed the use of cases that sought equal protection for men. And those were cases in which men, based on stereotypes about their roles in families, were being denied particular equal protection. And the effort there is to challenge the stereotype primarily of the male as the breadwinner and as a distant parent. And the stereotyping emerges then particularly clearly, I think, in the Virginia case. She wants to use the case to make a strong statement about the way that stereotyping undermines individuality and the equality of opportunity. And that's why she says that it may be true that most women would not choose VMI's adversative method, most women, but to extend then an exclusion of women broadly to the entire class, she says, is to rely on stereotyping that would exclude the one woman, maybe, who would be capable of and desirous of fulfilling those expectations. To exclude that woman would have only relied on a stereotype. To make that point clearly, she says it's probably a fact in the case, she says, that in fact this adversative method would not appeal to most men as well. And they're not excluded from the system. They're in fact given a chance as individuals to make a claim to this state benefit, the wonderful project. She asks, while admitting that education cannot be a one-size-fits-all prospect, whether the Commonwealth can deny to women who have the will and the capacity the training and attendant opportunities that VMI uniquely affords. But I think it's with respect to formal equality that perhaps Justice Ginsburg did less well. And that's a claim I make because the opinion leaves open, it makes so ambiguous the standard that ought to apply. I gave you my potential accounting. It's probably possible to parse it even more finely, that there are a number of possibilities for reading the standard that emerges from the Virginia case. And had Justice Ginsburg wanted to, or been able to, pursue this formal equality vision, this formal equality agenda in this case, it would have been incumbent upon her to push for a clear statement in the case that it stands for the elevation of gender to suspect classification status and the application of strict scrutiny. And the case does not do that. She would have been aware of that as a possibility, particularly because of her familiarity and affection for Sweden. In a 1975 Cincinnati Law Review article, she advocated very strongly for the possibility of this formal equality, invoking both Sweden's prime minister, in several quotations, who was launching then Sweden's campaign for promoting formal equality in that society, and quoting Harriet Taylor Mill in this order, Harriet Taylor Mill and John Stuart Mill, who themselves advocated for a principle of perfect equality. She might point then to Sweden today, which can claim that of women between the ages of 20 to 64, ages 20 to 64, 84% are in the workplace. That 83%, this is remarkable, 83% of children ages 1 to 6 are in municipal child care, and that 45% of the members of parliament are women. She would have been aware of those possibilities of formal equality and did not pursue them, at least as clearly as would have been required by advocating and articulating in the opinion the necessity of strict scrutiny for gender distinctions. I'm happy to talk about some suspicions I have as to why that's the case. I think they're all complementary of Justice Ginsburg, and they undermine many of the suspicions that are typical popularly with respect to her political position and the degree to which she's fond of judicial activism. But I'll save those for conversation later. Thanks very much.
Questions? I'm sure people must have something on their minds you'd like to direct to any particular panel. Yes.
I'm actually curious for the legal scholars and lawyers on the panel to the reaction to Justice Rehnquist's concurrence in the U.S. v. Virginia case, which seems to raise some of these same concerns that maybe the standard was pushed up by U.S. v. Virginia, but ends up concluding that under the straight intermediate scrutiny standard, which we feel is appropriate, the case would still be decided the same way.
I think at one level he was looking ahead, and that's a question that I would add to the discussion, which is when you have this sort of uncertainty as to is it strict scrutiny or is this intermediate scrutiny plus. What happens if in 2015 a new state says, we want to create an all-male institution of higher learning? We've got problems with how some young men are learning. We need to do it differently. It will look differently. It will be have elements of what VMI was. It may not be the whole adversative method. Right now, if you go to your Board of Education lawyer, they're going to say, oh, don't bother. Too much trouble. You're going to get challenged in schools. And I think Rehnquist was trying to keep in mind that there should be some more future dialogue about that question. And I think he's probably right. I think you might have a different opinion. I think if there were more votes, he would have joined the dissent. But I think he thought that there was no point making it 7. It was 7-1 because Justice Thomas recused himself. So I think he thought, why bother joining the dissent? Maybe I can say something else. I think the vote today would be much closer on this case. I think it's a 5-4 case, probably the same result, but much closer. Comment?
I think that Justice Rehnquist was saying, in essence, that you're raising the standard not quite to strict scrutiny, but you're making it something more than the intermediate scrutiny test. I think that Justice Ginsburg really was saying strict scrutiny for the very reason you articulated, Professor Miller, that if one woman, formal equality, if one woman wants to go to VMI, she has the constitutional right to do that. And so I think that Justice Ginsburg was not articulating it expressly as strict scrutiny, because I don't think she could have gotten as many votes as she did if it were expressly raised to strict scrutiny. Justice Scalia, in his dissent, certainly thought that this was an articulation of a strict scrutiny standard. I would just, if I could digress for 1 second, I can't resist saying a couple of things. When you think about Justice Ginsburg's philosophy about wanting formal equality for men and women, you have to remember that the VMI case is about young men and young women, and preparing each of them to reach their potential, to achieve real equality. And that's why I think the expert testimony was so significant, because everyone agreed, all of the justices agreed, but the experts agreed, that there are developmental differences between young men and young women. And some young men better reach their potential through a single-sex experience, just as some young women better reach their potential through single-sex education. So I think that there's not necessarily a denial of formal equality. In fact, if anything, by having diverse educational opportunities, you're better assisting everyone to reach their potential. Secondly, we're talking about institutions, and you can't, as a practical matter, design an institution for one woman or for one man. That just doesn't make sense. It's not economically viable for the state. So I think you take the best learning that there is, and if you're promoting diversity in education, isn't there room for a single-sex program for men and a single-sex education program for women? And finally, the catch-22, that if you, and when you admit women to VMI, you no longer have single-sex education, and you no longer have, over time, the unique VMI experience. VMI knows, as a responsible educational institution, that it has to afford the young women who go to VMI a good experience there. And I think that's what we're witnessing with the incremental changes over time. So I think that the catch-22 is an inevitable result, and it's the right result if you're going to give young men and young women at VMI the best educational experience you can.
I'm a little less optimistic or sanguine about Chief Justice Rehnquist's concurring opinion, and a number of other opinions on these questions. In some cases, inspiring dissenting opinions from both Justice Ginsburg and Justice O'Connor. Chief Justice Rehnquist advanced sort of the benign protective vision of women in the law. I'm thinking particularly of the cases involving selective service or the role of citizenship and women in immigration contexts. In those situations, Chief Justice Rehnquist advanced a more traditionally held view of the role of women in society, one that posits the law as protective of women's particular interests. And Justice Ginsburg would very clearly say that that although presented as benign and meant to be supportive of women, that vision, that approach to the law, has more often than not worked to our disadvantage. She very regularly quotes old saying in feminist circles that they don't want any handouts or benefits. They just want your foot off of our neck. And so I'm more suspicious of Chief Justice Rehnquist's concurrent opinion, that it may actually be drawing on that tradition, the tradition that kept women out of the practice of law.
My question is, how about the constitutionality of VWIL? I'm surprised it's not been challenged. I mean, there's nothing like it for men. It's state supported. I couldn't, I thought, as I recall it, the initial commitment by the government, I guess by Virginia, to that program was 5 years, I think. I don't think I'm making that up. In terms of the finances involved. And I thought that maybe what they would do then, at the end of that time, is to say, well, the transition has occurred at VMI. These women who would like the VMI kind of experience can go there. And VWIL sort of doesn't have its meaning for existence anymore. And to the extent that it does, do we have something comparable for men?
So who wants to litigate against that English president? I don't want to touch that.
She's not there anymore.
Okay. All right. Man, that's tough.
I suppose what you have is what, in the sense this case started, you have the ROTC programs, and that was one of the original sort of strategies, was that Virginia Tech offered for women something that was comparable to VMI. And I don't remember why that kind of did not turn to be a major issue in the case. I think VWIL has been successful on its own bottom. It is very different. It's funny, the VMI folks, while they supported it, and that was the option they pursued, kind of off the record, I won't quote anybody's name, for the most part, they didn't think it was anything like VMI. And at one point, there was kind of, I don't want to say derisively, they thought it was a good program in its own way, but it wasn't anything really like VMI. One of the early admissions brochures for VWIL showed the women cadets in their room, and there was a teddy bear on the bed. And no teddy bears at VMI.
Just like the cannons at VMI.
Oh, the cannons have been fired at VMI.
Here's a question about the 14th Amendment jurisprudence. After the Brodie and Brodie case, which deals with race, you have O'Connor's opening salvo basically saying the First Amendment, in a way, trumps the 14th Amendment concern for equality because we defer to the educational, the institution's own understanding of their mission. And she really backed off and didn't put it under the microscope or this magnifying glass of strict scrutiny, at least as compelling state interest. She basically said, if the school understands that diversity can be promoted, educational diversity can be promoted by these disadvantaged, or not disadvantaged, but what was the term? Underrepresented minorities. Wouldn't it be more difficult for the case to come down the same way after Grutter, if it had not been decided in '96, but had to be decided today or 2004? What would they do with Grutter as a precedent?
You know, this is the diversity issue that you tried very much to make. I mean, diversity, since Krautz and Grutter, is a constitutional watchword that has some meaning. You know, educational institutions can promote diversity. And the argument that VMI tried to make was you have 16 institutions of public education in Virginia. They do different things. This is one that's different. And I think the challenge you had there, and maybe you can speak to it, is you couldn't find a report from the Central Commonwealth of Virginia saying we want a diversity policy. You were kind of coming at it, you were saying we are different, therefore there's diversity. There hadn't been a study from the Virginia board that really said we want diversity and here's how we're getting it. And you were kind of the only diversity. What Ginsburg, who's taking this long view of history, looks at is she goes back to, hey, UVA was excluding women until just a few years ago. So she's got a long-range telescope going on, not the kind of microscope you're talking about. That is a very interesting question.
Well, I do think that we did make a record that at the level of the Commonwealth, there was an educational policy of diversity. Justice Ginsburg did not find it, but Justice Scalia's dissent refers to the 4 or 5, I can't remember right now how many publications out of the various commissions of the Commonwealth on higher education, which talk about diversity being one of the hallmarks of Virginia higher education, and specifically referring to the fact that having a single-sex institution is part of that. And of course, Virginia supports single-sex education for women at that time through the tag grant program. And, ironically, when you look at the Virginia system of public higher education, there were more women than men in totality in the Virginia institutions of higher education, more women receiving the benefit of tag grants than there were men. So when you look at the totality of the system of higher education, I think it was very difficult to say that the Commonwealth disadvantaged women in any respect.
That's the big distinction between the cases. That's a description of inter-institutional diversity at the level of, and Grutter speaks to intra-institutional diversity. I think those are really different sort of assessments. So you
First
can,
Amendment question, education operating a special niche in their jurisprudence and in a way, so the equality had to take a back seat for that sake.
Well, it does sort of, but there's still that intra-institutional aspect. I mean, one problem Virginia had is that Virginia's various state institutions really operate relatively autonomously. So you don't have a central government in Richmond saying, well, we're going to have an all-male institution here, maybe an all-female institution there, and this and that. It was the VMI Board of Visitors that voted on whether or not to start to admit women long before the case ever came down the pike, that special committee report. And they decided no, but it was up to them. It wasn't, it was up to VMI. The state wasn't saying to VMI. So since you didn't have a statewide pursuit of diversity, it was the individual board, and it's hard to say what an individual institution acting on its own to call that part of a program of diversity. That doesn't make sense.
Well, I would beg to differ, though, because it is true that the policy was established by the board, but the board only had the authority to establish the policy by reason of the decision of the legislature by statute to give the board that authority. If the legislature disagreed, the statute would have been...
The legislature could have acted differently.
And therefore, impliedly, the state was supporting the decision that had been made by allowing and continuing to fund the institution as an all-male institution. I'm sorry.
So, to take a different approach to this diversity of educational opportunities perspective, one of the things that strikes me is perhaps the problem with the VMI case is that it is exactly what some of the speakers for VMI said in a film, I can't remember which one it was who said this, but that it works, and that it was a tremendously successful culture. And I'm not speaking as a constitutional law scholar, I'm speaking as a specialist in gender and politics, and that is a warning bell to me. I think it is a tremendously successful culture delivering tremendous benefits to its alums, who are powerful and successful as a result of their participation in this culture, and who are therefore reaping at taxpayer expense access to something that they rightly covet, and that is not deliverable to all taxpayer children, and deliverable to the whole population. And I hear and perhaps I'm a little more sanguine about the catch-22 thing. I hear the catch-22 thing, but when I think about the question of whether what the state is delivering, if it's selectively delivering this extremely valuable benefit to only one sex, that sends off warning bells to me. And so then the diversity, to me, seems at least something that needs to be seriously examined from the perspective of equality.
Well, Professor Brodie talked about narrative, and I always look at Supreme Court opinions with that in mind. How do they tell the story? So I talked about the Kelo eminent domain case. The majority is always talking about New London and its poverty rates. Justice O'Connor in dissent is always talking about Suzette Kelo and her neighborhood. That's where they start. So you're absolutely right. Where does this opinion start? VMI is a very successful place, a uniquely successful place. So that, she goes, almost, I don't want to say bend over backwards, but she takes everything she can find about how good this institution is and how successful, and that, well, how can you then keep people out of it?
We're going to have to close, but I would like to ask Mike, how much has it changed? I mean, you were there as a student, you've been there through this whole case, you've been there to see where it is now.
Well, it has changed. I mean, with women coming to VMI, you lost some of the camaraderie that exists in an all-male institution, and I would certainly have rather VMI remained an all-male school, but we got an order. As General Knapp said, we saluted, and we were determined to do it right, and I think we have. And overall, I think some of the basic VMI principles are the basic VMI principles are still there, and that's honor, integrity, and a leveling type atmosphere in a rat experience, rat line experience. So I think in that way. VMI is still VMI. It's different.
Different in its methodology to some extent, as well as in having privacy in the women's showers or blinds that everybody pulls down.
No, I would say in methodology, I think we still going about doing the things that we've always done to make VMI successful, and those. The three aspects that I mentioned, I think they have remained, and I think alumni can be proud of that. But I guess going back to the fact that when you introduce women into that atmosphere, and you fundamentally change something of VMI, and so will women get the same exact experience? No, I don't think they get the same exact experience.
And by that count, I suppose men don't have the exact same experience that they had before.
Very true.
Well, thank you all for coming.